Hi, everybody. Welcome. I am here. I am here. Technical difficulties because court streams are often recorded via potato, and trying to trying to get all of the computers and things to talk to one another. Of course, that's where we started tonight. Hi, how are you? How's everybody doing? Where are you coming in from? What are you sipping on this evening? I have coffee. I have coffee because we're going to need it. I'm going to need it. I'm going to try and get us through the entire court day from Thursday in as quick a span of time as I can. We're going to zoom through a lot. I'm going to set things a little bit faster than usual. I mean, like 1.25 and 1.5 speed, in part because, well, for me, once I set Brennan to 1.5 speed, he sounds normal. And we are going to hope that I found my audio problems with how this court feed is so extremely low. I know I'm not the only one that was having issues. That's not an excuse. It's just sometimes we work with what we got, and what we have is incredibly low sound. So, without further ado, hi, welcome. Thanks for joining us on this, well, up here in Maine, very, very lovely but blustery day. And with that, I am gonna go ahead and roll the intro, and we're just gonna get right into it today. Hello and welcome to The Unfiltered Tea, a show where we say all the things you wish the newscasters said, unscripted and unfiltered. We talk about politics, pop culture, and courts, so pull up your soapbox, pour yourself a cuppa, and let's go. Let's go. I didn't pull up the stream like I was going to. All right, so where are we going to start? We are actually going to start at the very beginning of the day. There was a different hearing in the same courtroom that is between the Commonwealth and Aidan Kearny, also known as Turtle Boy, who Commonwealth wants phone records and stuff like that because in this latest documentary series, it has come out that Karen Read, first through an intermediary, and then just on her own, was communicating public information to Aidan Kearny, which has resulted today in a whole bunch of other motions. We won't get into that now. Right now, we're going to hop in the Wayback Machine. We're going to go to Thursday, and we're going to look at court. I have timestamps. I have notes. We will see if I manage to follow everything, and we'll see how quickly we can get this done. But it was a full day of court. So get comfortable, hang out, and we are going to start with this. We're going to start with this first hearing because everybody wants to see it. It was enlightening. It was a different vibe. So that is where we are going to start, and then buffering. That we'll just go from there. We're gonna try and get this all done. All right, add to stage. No, make me over here. There we go. All right, and let us hope that the audio is good to go. Great. And I'm being told that my visual is out of sync with the audio. So I am going a minute, and I am going to come back and see if that helps at all. It's just a day for tech. It's just a day for tech. So let us dive in right here with Brennan making his argument for this. So yeah.
Specifically says under these circumstances,
and the glitchy on this, it is the feed. It is not us. It is the feed. It is not us. Because Mercury is still in the microwave for another week. So that's just, I'm blaming that.
Lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. But these are a bit unique in circumstances in that I am a specially appointed prosecutor to Karen Reed's case, Commonwealth versus Karen Reed, and Judge Cosgrove, Special Prosecutor Cosgrove, is specially appointed to Mr. Kearny's case. Because of that, I have, from the beginning, kept a very strong line of separation between both Mr. Kearny's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket. And so what I learned is from my public reading and from watching hearings. And so what I know is that
Sir, I got to make you go faster. I said I was going to do that, and then I didn't.
Trooper Tully, and is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to
There.
Reed's case.
Now he's at 1.5 speed.
Important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Kearny, but a relationship in where information, some of it private, some of it suggested grand jury minutes, was passed purposely from Karen Reed to Mr. Kearny. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to...
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why I...
Let me ask you this, Counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
I love this judge.
From the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or asked questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware.
I love this judge. I love this judge. He's like, hey, sir, you have an argument that you are trying to make. You haven't made it yet. Please do better. I'm paraphrasing, but I love this judge. Okay. And I'm going to try and adjust audio on both levels while we're watching.
Guilt is a different standard than trying to prove a case of intimidation beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Kearny's phone, is that there was a relationship between Karen Reed and Mr. Kearny, in which Ms. Reed would provide information indirectly to Mr. Kearny. That information would then be reviewed by Mr. Kearny, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Kearny targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Kearny, that this trial of Ms. Reed never go forward.
This is all about witness intimidation or supposed witness intimidation that is happening. So, yeah.
We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make an initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearny and the defendant?
Yes.
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearny and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through including October 5th, 2023. 7 months of material that ostensibly could include everything from meeting notes, calendar invites, text, videos, things that have absolutely nothing to do with communications between Mr. Kearny and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First,
I love every part of that. First of all, he's in the middle of being like, "You asked for too much, sir," and then, oh, the way they just walk in and go right to council table is, that's a bold move. That is a bold move.
Ruling with Mr. Kearny, so I'm asking that Mr. Kearny has started being at the table. I'm not sure why we're being joined by Ms. Reed since they have standing in this.
Your Honor, we're a little confused. I don't mean to interrupt the proceeding, but as we're... Counsel, can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of Mr. We didn't see which case number was called. It was Rule 17, if it was Mr. Kearny's case number, or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Canoni, was if this issue was going to be on our case number. I specifically asked that question at Sidebar the day before yesterday, and she said, yes, the Rule 17 Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the issue
This meeting is being
Counsel,
recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearny. The case number that was called was the Commonwealth versus Kearny.
00117.
Okay,
That's correct.
then she needed to be here, and she has a right to counsel, and we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
I'm going to slow him down just a little bit.
It specifically pertains to the prosecutor asking for information in her case to move forward her consciousness of guilt, etc.
Those are evidentiary issues, counsel,
Correct, but we
which can be dealt with at a later time. Those are what you're suggesting are evidentiary issues, which are not before the court. All of it before the court is a Lamprey hearing on material sought for Mr. Kearny's case. The evidentiary issue will be dealt with at a later time. This is
and respectfully, I don't necessarily disagree that from an evidentiary standpoint or a disability standpoint, that can be dealt with at a later time, but the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearny's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearny's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. Correct. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're prepared.
Did you give the court notice of that?
We did to Justice Canoni.
Okay.
The day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished.
I don't want to interrupt Mr. Brennan's argument, except I just walked in and took over the entire courtroom. Truthfully, I would rather the entire case was being heard by this particular judge rather than Judge Canoni. And there's a reason for that. This judge doesn't seem to give a flying flat doodle which side you're on. You're going to stick with the rules. You're going to stick with the law. And that's what you're going to do. And if you don't do that, he's going to yell at you. So they went back and forth. Everybody made some arguments. Let me pull up my notes so that I have them. They went back and forth. They made some arguments. I'm going to try and zoom through a fair amount of this, because bear with me while I'm reading my notes. We have Ms. Little speaking for Ms. Reed. I can pop ahead to that. You know what? Let's just skip ahead to Karen Reed's motions, because again, I am trying to get through a full day of court. And there are plenty of folks going through every last little bit of this. And I can, if you want me to, down the road. But for right now, I want to get to all the good stuff and the stuff I really like, which is, no, why? Ugh. All right, well, this is close enough. So we are going to start. So now we're going to zoom right ahead to Karen Reed's actual hearing, and the difference in judges is palpable. Motion from the public to switch judges for everybody's sanity. I think that would help. I mean, except maybe Brennan's. I don't think Brennan's sanity would hold up, but who knows?
Canons do
You shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117.
Oh, I missed the
Commonwealth versus
Kyrie.
Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Barbara Bachman for the Commonwealth.
For the Commonwealth. Good morning, Your Honor.
Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yanetti for Karen Reed.
Good morning, Mr. Yanetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read. What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately.
Right. All three indictments, correct? You're defending all 3.
But it starts with murder. That's the sun rises and falls on a murder charge. There's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that probably is the better practice. And we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance.
So the point of this is everybody agrees that if we impanel a jury and jeopardy then attaches once the jury gets sworn, and then let's say this appeal comes down and they're like, oh yeah, there's no standing for counts 1 and 3, including that murder charge, then it basically you have to throw the entire case in the bin and start all over again. Everybody has to start all over again. And everybody's like, can we not do that? And I'll let her explain her compromise.
All right, does the Commonwealth want to be heard on this?
Of course they do, because they always do.
Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse.
Speed you up, Brennan.
The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different. But most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right. We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st, at a minimum 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches, and we'll take it from there, but we will start April 1st with impanelment.
Thank you, Your Honor.
Okay. All right.
The way this judge is just like, I have a schedule to keep, and you are not going to interrupt the schedule, is it is astounding to me. I understand that she doesn't want a group of folks who have done a whole lot of work for a whole lot of time to have to start all over again, but he's too quiet. I need a new goat. I just this is why we're all watching this case. This is why we're all watching this case, because stuff like this keeps happening. All right, I'm gonna let you continue.
Right, so let's go to the next motion, and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it.
And yes, I sped everybody up again because we need it.
So we did hear from people this morning. I know you all have. I have it. I have it, Jim. I think Mr. McDermott gave you a copy of.
Okay, we're going to skip over this because this is buffer zone arguments, and we're going to skip ahead. Basically, what has been going on in this trial, if you're brand new to the trial, hi, welcome. It's a little crazy. So what's been going on in this trial is outside of the courthouse, there are supporters of Karen Reed, and there are folks who absolutely think that she is guilty, and they are both protesting. So now we've walked into a First Amendment issue, and everybody is loud about it. And it seems in this courtroom that you can hear everything. So for the last trial, there was a buffer zone of, I think, 200 feet outside of the courthouse, but then jurors commented after that trial that they could still hear all of the shouting and cheering and stuff like that. So the Commonwealth wants to increase the buffer zone. It is a tough thing. Here's what I would say. I'm gonna soapbox for a minute here. Here's what I would say on this. No matter what side you are on, first of all, if you are on the side that thinks she's guilty and you are claiming the Justice for John O'Keefe thing, let's be pro evidence, because that's where I'm at. I want the evidence. Commonwealth didn't bring it in the first trial, but if everybody could be quiet to allow the court to do what the court needs to do, that would be great. Have your signs. Have your signs. When court is on break, cheer, what have you. But if everybody could just take a moment and while court is in session, respect that I don't care what side you're on, in order to assist them to do their jobs as best as they can, zip it. Go to your local favorite haunt or to a park or something. Just zip it. It would make life that much easier for everybody. Okay. Now we are going to go back to this. I am going to zoom ahead a minute.
Have requested. Okay. All right. So I'll hear the Commonwealth on your buffer zone motion.
Okay. Nope. We're gonna skip ahead. Commonwealth has their motion. It's fine. Where is my? Okay. Here we go. And then everybody's going to get confused.
That one issue, just briefly.
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote in their witness list. I think, they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
The number of times this happens. Hey, Judge, we at the defense have complied with our discovery obligations. We still need information from the Commonwealth. It's too quiet. I need a louder goat.
So there is a footnote. I'll hear you, Mr. Brennan.
Your Honor, the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived
Of course they do.
harassment and intimidation of witnesses, which the Commonwealth believes is ongoing. I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from.
I don't have a problem with that. I still need cities and towns.
Of course.
Okay.
Yeah.
All right. Thank you. So we will start with,
I should also note that a whole lot of their witnesses are connected to police officers, and yeah.
it's paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminate to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
Of course it's Brennan, because it's always Brennan.
Commonwealth first, Your Honor.
Well, it's defendant's motion.
Which
The
means
Commonwealth opposed it.
You would ask who's arguing that for the Commonwealth. That's why
I'm
I-
sorry,
I-
defense motion.
Okay,
Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever.
I'm fine with him going first. if you'd like.
Okay.
And now just everybody's confused. Everybody's confused. No, Brennan, I think I'm going to skip you. Hang on. Yeah, I'm going to skip you. This is, well, no, I'll give you a little bit.
I think the heart of this motion is that the defense would like to introduce the ARCCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the time they wrote the report.
Because they were.
And subsequently, being employed by the defense has no impact on their objectivity at the time they did their investigation and report.
Correct.
I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial.
Only because you're convinced that your evidence is the only evidence and you don't like that they came up with a different reasoning. That
As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office.
because you guys were the subject of the investigation.
Office and ARCCA, and what, if any, impact the defense had on ARCCA witnesses at the time they did the investigation. What we know.
Random question for y'all. Do you guys think that the FBI is going to investigate a police investigation in a small Massachusetts town where they have just the word of a defense attorney? Do you really think that's going to happen? And do you think they're going to call the Commonwealth and be like, hey guys, we're looking into you? Because I feel like that's not a thing that the FBI is likely to do. I feel like the FBI is going to take under advisement whatever tip they got and then look and see if there's any evidence to support it and then go into it. But that's just me. That's my thoughts. If you think something different, let me know.
Investigation. We know that a number of experts were retained by the federal government, including the ARCCA witnesses.
Mm-hmm.
What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware
Okay. The ARCCA witnesses went over all of this. They did. Okay. Let me look at my notes. And we're gonna zoom ahead. Yeah. And the judge says she's gonna need a voir dire again on this. Fine. Initially she wants a voir dire like next week. And everybody went, what? Ma'am? So yeah. Let's see. Oh, let's skip ahead to my little note where we have Yanetti and hang on. I need 3 screens apparently, and I only have 2. So bear with me while I zoom to the next bit. We're gonna cut, like I said, I'm trying to zoom just as quick as I possibly can, guys. Through all of this. And that's not quite where I wanted to be, but it's close enough. Let's go.
In this case, I asked the court to do that.
Any objection from the defense?
Yep.
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is.
Hi, Dad. Thank you. All right. Yes, I'm going to pause. And I'm going to explain this. Why do I follow all of the attorneys on YouTube? Yes, I do. They're linked in the description below because their content is super helpful for me to understand all of it. And I highly recommend them when there's at least one on that list that will suit your court watching proclivities, I think. And I have learned a lot of law through them. So let us go in the Wayback Machine for a moment so that I can explain the ARCCA witness, ARCCA, I think, but it may be ARCA, and I can't remember now. So in trial number 1, there was an FBI investigation into the investigation of the murder of John O'Keefe because it was objectively horrible. And we will get into some more details of that later in these motions. But the ARCCA witnesses are biomechanical engineers that were given a set of, basically, if I'm remembering trial 1 correctly, they were given this is what the Commonwealth thinks happened. This is what the defense thinks happened. What does science and math and physics say is most likely? And they came back with a report that basically said the idea that she backed up and hit him intentionally with her car, or not intentionally, that the backing up and hitting him just scientifically was not possible. And then they were working with other bits of evidence that they had, such as the glass on the bumper of Karen Reid's vehicle. And that glass didn't match her tail light, and it didn't match, I think, the cocktail glass, but I don't quite remember. So with trying to figure out the broken tail light, I'm jumping ahead a little bit, but one of the coolest things that they did was they built a cannon to fire a cocktail glass at a tail light to see at what velocity would a glass have to be going to hit the taillight and shatter it the way that it was shattered, right? That was, if you have not seen that part of trial number 1, highly recommend looking up that. ARCCA, for the most part, they are unbiased witnesses, which is why the defense wanted to use them, right? Because they got to avoid all of the questions of how much were you paid to have this testimony. Fun fact, guys, fun fact. Every expert gets paid to be an expert. It's why they're experts. So if they're on the stand being an expert for any side, they have been paid. And I don't care if it's the medical examiner who is on the Commonwealth's regular payroll, or the ARCCA witnesses who in this case were on the FBI's payroll. This has become a whole big thing in this. I tend to agree with the defense, and I think they were some of the defense's best witnesses, in my opinion, because they were just like, we follow the science and the math and the physical evidence. And if it's not there, we don't follow it because that's not what we have to work with. And they're willing to come back and testify for the defense again. So, of course, the Commonwealth, because they're real bad for the Commonwealth, like real bad for the Commonwealth. So they are trying, the Commonwealth is doing everything they can to try and keep it out. Also, part of the reason this is coming up at all, and we're dealing with a voir dire with them, is because in the first trial, everybody was at the mercy of the FBI. If the federal government didn't want to turn over the information, the federal government didn't turn over the information. And so you have to comply with discovery, right? Discovery is both sides have to give a certain amount of information to the other side. If the defense has to get everything, the defense is required to turn over reciprocal discovery of a certain level. And they couldn't comply with that order because the federal government didn't give them what they needed to comply with it. So the remedy for that was to bring everybody into the courtroom and have everybody ask questions. And then the judge was like, okay, I'm satisfied with all of the answers to all of the questions, and it seems like it would be helpful for the jury. So yes, they can come testify. I think that's a pretty good, yes, accident reconstruction, something. I will try and look it up, but that, in short, that's the ARCCA witnesses. If you are in some of the places of the internet that I hang out, they are also known as the crash daddies, because we like to have fun with names sometimes. So, yeah, also known as the crash daddies, because they're the ones who figure out what does the science say. So now that I have digressed,
Pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors.
Well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion perhaps incorrectly that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Well, that's what I went to.
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a change.
This is a new trial, Judge.
Right, no, so just to be clear, this is a change.
They have no chill. I don't know what happened between Yanetti and Judge Cannoni at some point. I mean, same jurisdiction and all of that. I'm sure they have crossed litigation before. I'm sure that they have. But boy, they cannot stand each other. And it is so clear. Also, side note, defense team, if you happen to come across this, first of all, hi, thanks. Big fan of a lot of your work. But if you happen to come across this before trial, can I just say, for the benefit of, I think, everybody, somebody with this judge on the defense team is going to need to be the designated asshole. I think it should be Yanetti because he's not pro hoc. So I feel like that's a little bit more of a protection for you guys. So yes, somebody is going to have to be the designated lightning rod for this judge going into trial number 2. She loves Alessi. I think Yanetti should take this one for the team and be all the things that you gotta argue that you know she's gonna hate, like hate. Yanetti, I think you should be the one to make that argument, because if Alan Jackson does it, she will kick him. She will boot him and yeet him back to Los Angeles. So, just a thought. Just a thought. Sorry about that. Sorry about that. Before we go back there, because that was definitely a squirrel moment. Okay, now we can go back. I'll let you chat a little bit more, Yanetti, while I find my next
I don't
timestamps.
recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a court would be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information. But the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
Also, sir, you guys are kind of the reason that it is as public as it is. No shade in that. I'm just saying you help facilitate that, and I happen to agree with you. But that's because I want all the tea. Hello, the unfiltered tea. I want all the tea. So, all right, Brennan.
So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
I don't have an answer to that. It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it.
Sir, you knew this argument was coming. You knew this argument was coming. Everybody had papers. You filed in opposition. You knew this was coming.
I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt.
Stifle? Stifle? Sir, I understand it's a thing to read words and not know how to pronounce them and then say them and then get corrected. Hi, avid reader growing up. Stifle? You realize that's been memed into oblivion at this point, right?
To deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion to cottage industry in ways, unfortunately. And that creates an enormous...
Huh? Oh, huh? I'll understand.
enormous amount of
I don't
social media
understand,
and
Brennan.
media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right, so I am taking a lot of these motions under.
That was a whole lot of words. First, Your Honor, I didn't do the homework.
Advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Whole lot of words for I didn't do the homework. All right, what's next? Whole lot of words for I didn't do the homework. Okay. Before we zoom, I am looking at my notes here because next up, Ms. Little argues for the manner of death to be allowed. This is, okay, let me embiggen me for a moment. Here's why Ms. Little is arguing for the manner of death to be allowed. Under many cases, especially murder cases, it's sort of a default I have learned to redact the manner of death. And that is because the term homicide on a medical examiner's report doesn't necessarily mean what we think of it as colloquially, right? So it puts the presumption of guilt in jurors' minds. And so it's usually redacted, and you don't necessarily talk about it in that way until you get to trial and you're dealing with evidence and stuff like that. In this particular case, we have a little flipsy-do because the Commonwealth is trying to get the manner of death redacted because the manner of death was undetermined. Because what the injuries that John O'Keefe sustained and stuff like that, the ME never put homicide down on the report. So in this case, the defense is arguing to have that allowed in. And there was a little bit of a confusion where Ms. Little said that the medical examiner was not on the witness list. She is on the witness list. I suspect that what happened is in conversation with the Commonwealth, because conversations do happen between lawyers, that the Commonwealth indicated they weren't going to call the medical examiner because she wasn't exactly helpful to the Commonwealth's theory of the case in trial number 1. But yeah, so there was a bit of confusion there. It did get sorted out, but that was that argument. Then let's see. Okay, let me jump ahead just a little bit, because the judge had said she wanted the ARCCA witnesses to come in next week for voir dire. This would give the Commonwealth a huge advantage because basically they would get an option to cross-examine these witnesses well ahead of when the witnesses are going to be called in the trial. Luckily, she thought on that just a little bit longer over morning break, and the judge did, and realized that that wasn't really great for anybody. So she updated with they are allowed to do the voir dire the day before they testify. That means that they can travel into Massachusetts from wherever they are and do it in one trip instead of making 2 trips. And Brennan was not happy with that. And because it means he's going to have to scramble. And I'm not sure how good he is at scrambling. I don't know. We're not in trial yet. So that is where we have there. Then we get to Alessi's motion to exclude Dr. Welchler. And because we all need a little Alessi in our lives, grab your dictionary or your thesaurus because the man is a human version of both. brush up on your Shakespeare as well, which will not hurt, and let us zoom ahead to Alessi's argument. I am going to keep everybody at 1.25 speed, and we are going to have the judge's joke that Alessi was not amused by at all. At all.
May it please the court. In my presentation today, with regard to Dr. Welchler.
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me.
Yep. Because that is usually what he does.
Do you plan on doing that, or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
In my presentation today, Your Honor, I'm going to, just so Your Honor has the document.
Yeah. I didn't change that, did I? Nope, I didn't. Let us back up again. Let me come here. Let's back up. We'll go through that again because it's very important to see the faces. Streaming is dynamic. Sometimes I don't hit the right buttons. Whoopsie doodle. All right, Alessi, apologize. Thanks, Dad.
May it please the court. In my presentation today, with regard to Dr. Welchler.
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that, or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
He totally planned to do exactly that. And he pivoted real frickin' fast to, and it's funny because if you see everybody's faces in the courtroom, everybody's amused. The judge thought she was making a good-natured joke. You can tell Alessi was not amused.
In my presentation today, Your Honor, I'm going to, just so Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140 slide presentation, okay. What the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025 from Dr. Welchler to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welchler has submitted is notable both for what is submitted and what is not provided. Dr. Welchler has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance, or any of the Dalbert factors. And this, again, is a pattern of the Commonwealth where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CVs, long qualification lists, and then are completely silent on the tethering of the methodology to a common acceptance or the Dalbert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000. And I am going to provide 4 parts of Canavan. Number 1, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welchler, what happened with Dr. Wolf and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative. That's the ipsi dixit, comes right and is used in case of candidate. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welchler is doing in a 140 slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan.
We can all take a moment here, and I'm going to zoom ahead, because, we're trying to get through the full day of court, and we've got through ipsi dixit, or the Latin for because they said so. I will tell you, every time Alessi stands up, I learn something new, a new word, you have to have dictionary.com like as another tab when you're watching this trial anytime it gets up. And I am going to skip ahead. He also has a great line of there are several maladies with that statement. When Brennan is like, yeah, but he's a good expert, we should let him in. And Alessi, of course, goes through point by point by point, debunking everything, because that's what Alessi is really good at. The judge asks Brennan, do you tend to introduce that? Which in this courtroom is basically, we all can translate that of the correct answer, Brennan, is no, and then Brennan basically answers that. So, okay. Let's see. Now we're going to skip ahead to Alessi's final statement on this particular matter and Brennan's reply. We're getting there. We're getting there, guys. I'm trying really, really hard. I might have to do this in two parts, but it's not going to be an hour tonight. It might be a little bit more than that, but I'm trying to zoom through all of this. So, let us skip ahead to the end of their back and forth. You can see why she put a time limit on them at the end of this. We'll get to there.
To say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welchler are completely absent with regard to that tethering. And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion. I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush. And that's not my standard. That's the standard of the SJC. So we respectfully request that Dr. Welchler's report and his testimony be disallowed in its entirety. We will, of course, await the narrowing as Your Honor has ordered, and we would urge at a minimum that the defense know clearly
Stop zooming
what
in.
this witness is going to be allowed to testify to. And we would like to avoid an evidentiary hearing because I think it's pretty clear what the parameters are. But I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Yeah. Yeah.
Brennan?
I'm particularly disappointed that Attorney Alessi sees this as some type of trial by ambush. I'm not going to digress the way he has, but the case study in that is the ARCCA, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery.
Sir,
And Mr. Welchler have some similarities.
you are the king of this happens every single time.
Because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welchler. We gave any reference material.
Hey, nerds, or not nerds, anybody younger than, I don't know, 90. 8 gigabytes. It's not a lot. 8 gigabytes is not a ton of data. He says these things as though it means something, and it could be 2 photos.
Whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production. But Dr. Welchler gave his entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welchler is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what
Oh,
Perry
come
looked at
on.
in this case. And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welchler, Dr. Welchler cannot come in and talk about the opinions or testimony of witnesses as it relates to their statement. So, for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or anything that relates to it. Similarly, 2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it.
Witness testimony isn't science.
Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welchler.
Correct.
So
part of the argument that I did skip over is that Mr. Welchler is making assertions in his report, according to Attorney Alessi's argument, about which witnesses are credible and which ones aren't. And experts aren't allowed to do that. So, yeah.
the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welchler or he was talking about the ARCCA experts. Because
Oh my God.
when I'm looking at the ARCCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCCA report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand.
Well, it was a cool idea, but also he did it because they were trying to figure out how glass got on the bumper. They were using your evidence, sir, and trying to fit something to the story that you claim was a thing. Just because you don't understand the science and you don't understand the report doesn't necessarily make it a bad report or bad experiment. Bad experiments, FYI. Okay. My blood pressure is rising, so we are, the canon was so cool. If you haven't seen it yet, go back to trial number 1 and find it. I can't remember which day it is. If I can find which day it is, I will link, one down below. So, let us zoom to where are we at? Let me zoom ahead. Okay. Then there's a whole bunch of stuff that they agree on. There's a whole bunch of motions. It's like, any objection to this? No. Any objection to that? No. Great. We don't, that's all going to come out in trial. So we don't need to see that. Then we have motions for John O'Keefe's cell phone data because Brennan is trying real hard to, bring in as much cell phone data as he can on the basis of consciousness of guilt. So far, he's kind of failing. And then Alan Jackson and Brennan enter the WWE ring of hyperbole and going at each other back and forth. It's basically the court version of a Snickers commercial. And now I am going to zoom ahead to where the judge pulls court over to the side of the road so that everybody can go to lunch, because I personally find it amusing. So, let's see. Nope. Eh, there.
So we're going to break. We've got a lot of ground to still cover. I suggest that we take the personal attacks completely out of this. Hold on, both sides. I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods, all of that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2.
Your Honor, if I could say one more thing. As the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave it.
Side note, that is the first time I have seen the Commonwealth get wrapped up into it. And to be fair, Alan Jackson had to go, but Mom, he started it. Which he did, but oh my goodness. I'm not even thinking about that for the next hour. One of my favorite moments with this judge, and I don't have a lot of them. Let's see. Now we have court being back with some time limits. So that's entertaining. Let's watch just a smidgen of court coming back where she sets time limits on everybody, because it is kind of fun and they're better attorneys. And frankly, she does better at her job. Like, everybody just needs to stop watching this in this court. So, zoom. There we go. No, I'm going to zoom. There we go.
Out of time. Spend some time talking about voir dire, so I don't want to run out of time for that. So what I plan on doing is finishing these motions by 3 o'clock. I'll give each side 2 minutes. We'll see how we do with that. And
she is so done.
Jury questionnaires, have you provided those? Remember we talked about it the other day? Have the two of you worked out a jury questionnaire?
I know you asked us, we have not. We haven't.
All right, so today's the final trial conference where I'm supposed to have all of this, right? Can you do it before you finish? Well, let's see where we get with the motions and we'll see it.
And Your Honor, if I could I finish that last point that I was asking just before we go?
30 seconds, Mr. Jackson.
It'll take me 30 seconds. I want the court to be super, super clear about this one. What Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview. The reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. But on the 28th, calling John to say 34 Fairview is down the street from Ashley's house.
Pause. I missed a thing. So if you have seen the documentary series that just dropped, if you saw the first trial, if you saw any of that, there is this ex-girlfriend that came up a lot in the first trial. She's in this documentary series. For me, it's weird. It's weird. Every time it's weird for me. And so there is some argument over when Karen heard about this person and when that came up. And Alan Jackson wants it clear that it came from Jen McCabe and it came into people's information the day after John was killed. So that is what they are talking about there. If you've seen that, let me know what your thoughts are on this ex-girlfriend. Like, I get that she had feelings for him. I get that she misses him. I get that she is grieving him. It just feels the vibe is off for me. So I don't know. Let me know what your thoughts are. I'm curious. It could just be me. You know, I know a lot of people, the vibes are off with Karen, and I am not picking up on that myself personally. So, you know. All right.
My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Okay.
Then the next day is when the conversation, according to Jen, took place about Ashley and could it have been some sort of an interaction or an affair or something like that.
Okay.
My only point in making this, and I just want the record to be super clear.
I understand what your point is in making
There
it.
was no animus, no evidence of animus on the night of the
I understand that's your position. We haven't heard the evidence yet.
Closed captioning.
All right, thank you.
All right. Well, Mr. Jackson, you can stand up again. Is the defendant pursuing a third-party culprit defense?
That's going to be my colleague, Mr. Yanetti.
So you have 2 minutes, Mr. Yanetti. That's sort of a yes or no, and then I'll hear the Commonwealth.
And I'm sorry, I did not hear the question. Yes.
All right. So I'll hear you on your motion, Mr. Brennan, and then a 2-minute response.
This is kind of great. We'll run through the first one with them on speed. Not
Thank
on
you.
speed.
During the first trial, Your Honor made a ruling prior to defense presenting any evidence or questioning any witness about third-party culprit. The defense needed to provide a sufficient evidence to pursue or place that issue in front of the jury. The defense, in my opinion, looking at the opening argument, ignored that directive by the court. The very first words of the opening were directed to third-party culprit. And thereafter, throughout the case, there does not seem to be any boundaries, parameters, or identification of the walls or the length of third-party culprit. The varying representations by the defense over time make very unclear what the third-party culprit evidence is, whether it is a particular person, includes particular people, or unknown. We know from the defendant's statements that there was a position taken on the front of the courthouse steps that everybody knew who the third-party culprit was. That position changed in the Ted Daniels interview when they were asked about third-party culprit, Mr. Jackson, and the defendant said they did not know. And so despite the recent position that they did not know who the third-party culprit was,
I feel like they don't know for sure, but it's a pretty solid guess that we are looking at one of the Alberts or somebody like that. I think they have laid out pretty clearly a range of folks who were in the house.
in our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert. And so there is this vacillating position on who the third-party culprit is and what evidence they suggest supports third-party culprit. I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point. And so what we have now is the defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit, and they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the
So
defendant.
I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
See.
I've read your motion. I've read your memo.
Okay.
Or the pleadings.
Thank you.
All right, Mr. Yanetti.
It is kind of nice to watch the judge be like, "No, sir, your time is up, and I've already read what you put out there." And then this is the reply, which is delightful if it's the one I'm thinking of.
Jim, why don't you stand? Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
All right, Mr. Alessi.
Move it to the back of the pile.
Motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
Okay, we can skip ahead from this. It's if you want to watch the full thing, if we want to take a look at that, we can always circle back to some of this. Again, I watch all of this, but it's not always the most fun. Unless you're a total nerd like me, about law, politics, things like that. So now let us. It is kind of fun to watch them go through it because it's basically like the judge put them on 1.25 speed, and it was kind of wonderful to watch. But we have some very big things to get through before I say goodnight. So we are going to skip ahead. Mostly to, let's see, to an Alessi rebuttal, and it's mostly because I love Alessi throwing shade. It is one of my favorite things to watch, so we're going to skip ahead there. No, back. There we go.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in trial one. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to.
That's the Alessi shade right there. Like, sir, Mr. Brennan, I know you claim you've read the transcript, but I've read the transcript and I've gone back and watched the video.
I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration, what it's going to be. They're looking, to me, this is a blank check. Similarly, with regard to Jessica Hyde, we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague again, we have no idea what it's going to be, nor does the court. And there are similar statements, and also on page 2, they concede they want Mr. Whiffen to use the highly disputed extraction reports to demonstrate Celebrate software. Says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. And secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contains several camera angles of the property. And the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
All right. I appreciate your brevity too. Thank you.
You're welcome.
I had to.
Mr. Brennan?
He ended up on like 1.75 speed because he was going so fast. We're going to speed him up.
The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data.
This is Cellbrite data.
How the data is stored and
how's long to die in the cold.
Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different than hasn't already been provided.
All right, we're going to skip ahead to... We're almost there, guys. We are almost there. We are jumping ahead to the end of the day. And let's see, we are jumping ahead to the end of the day. This is the motion to exclude Garrett Wing and Mr. Mike Easter, which the internet has already taken that and run with it. And I'm going to leave them on 1.25 speed, but this is the end of the day, and it is a great argument. So we're going to finish up with this. I am going to summarize a little bit. Well, then we'll summarize and we'll see what the plan is next week. No, zoom. Guys, why are we doing this? Oh, it's the only fan. Sorry, I thought I had my timestamp correct, but clearly I did not. Let me check my timestamps again. Streaming is dynamic. Nope, definitely had this wrong. Nope.
Person, and why haven't you complied with your reciprocal discovery obligations?
Your Honor, because this witness is pending Dr. Crosby, and he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question. But that's the purpose, is to address if Dr. Crosby is going to be allowed to testify, and if so, as to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration, whether I think I need to rule on it or not. I'd like you to...
You should reconsider that, Judge, because I do not understand why you decided to let this dude in after putting Dr. Russell through all of the voir dires, and you're not even giving them a voir dire. I'm going to be big mad about that through trial.
The discovery on this, just so we can keep things moving. We don't have to suspend the trial.
We will do so, Your Honor.
All right. So, what do you say, Mr. Brennan?
Well, discovery deadlines have passed, and the Commonwealth shouldn't be in a compromised position of receiving late discovery and trying to deal with it. So I'd like a time certain.
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all your reciprocal discovery?
I wrote my time wrong.
I do not, and not only do I not have all of it, I need to go take a look at to make sure, in light of recent events, that I provide everything to the court. So I can meet a fairly short deadline, assuming I can communicate 3 days.
But it is wonderful.
Yes.
Is that acceptable, Mr. Brennan?
Yes. All right. Thank you, Your Honor.
Thank you.
He's working through the weekend, I'm sure.
667, Jim, is the defendant will provide reciprocal discovery by Monday, the 24th. As for Michael Easter's opinion of the investigation.
There we go.
Hear you on that, Mr. Brennan. I figure this is probably lengthy.
Sorry, guys, I wrote my timestamp
This might
wrong.
be more than 2 minutes. Might be lengthier than the others.
Yep. I have
I would
everybody
like to
put
call
up still.
Mr. Easter to essentially testify about his personal opinions of the investigation, and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is,
I'm going to
from my
slow it to
perspective, tantamount to
1.25.
having a witness come in and vouch for the credibility of defense arguments and essentially summarize arguments. This really, from my perspective, is the role of the defense attorney, to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses, and then...
Sir, the police officers thought that putting blood evidence in red Solo cups and then a Stop and Shop bag was a good idea. You seem to think there was nothing wrong with that. This is why this guy is being called in.
the witness would have the opportunity to respond or explain or admit any type failures. This is an attempt to bolster a potential Bowden defense and a third-party culprit defense.
Yep.
It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be.
Mm-hmm.
That would be totally improper opinion and inadmissible. They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come and promote the defense theories, tout reasonable doubt, and suggest why somebody else committed the crime.
I don't see that the defense is allowed to defend. The defense is allowed to defend. If they have a former FBI agent willing to come and testify to the fact that this investigation made several other famous cases look like good investigations, then great. Sir, just because they're making you work for it doesn't mean it's a problem. Let's zoom to. All right, we're gonna zoom ahead to Alan Jackson and his response to this.
Seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent?
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation should look like.
How is he an expert on that? How is that a field, and how is he an expert on it?
Ma'am, literally anybody with eyes and having watched, I don't know, a news report or an episode of Law and Order knows how bad this investigation was.
I'll go
Is
through
it
that.
something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues specific to proper investigations and investigative techniques.
So do you have a report in CV and all that material
Yes.
that you can share with me?
Sure. I've already shared it with the Commonwealth, but I'm happy to share it with the court as well. If I think I can address many of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, etc.
So is the basis of his testimony just crime scene, like collection of evidence, or is it
witness interviews?
When somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too, both. Because if someone tells you as an investigator, someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing, logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept, and why those logs are kept.
If you missed it, there has been no chain of custody. There are no pictures. The way photographs were taken were terrible. Just all of it. When I worked campus security and we were the laziest group of security officers on the face of the planet, we had chain of custody things that we had to keep. I don't understand how there's no chain of custody.
You bag evidence, how you secure evidence, how you maintain the integrity of evidence, and things of that nature. There is certainly, I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked them up, looked at them side by side. They're nearly word for word. And the advisory committee notes for federal rules of evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects, but also the large group sometimes called skilled witnesses, such as bankers and landowners testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the rules of evidence 702, the federal rules of evidence 702 clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the Rule 702 allows for experts with specialized experience, specialized knowledge, specialized education, beyond that of an average layperson, in particular, in a field without, or in a particular field, without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formally coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was a lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member.
I have not looked this guy up, but if this is like anything else with the defense, they have just found the most expert cop on the face of the planet.
11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe, all.
I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either what I was reciting is either in the CV or in his report. What
Okay,
are
so
the other?
that's what I need. That would be much more helpful to me.
Then I don't know what more the court would like for
So
me
I
to have
wanted to know
specific.
specifically what you intend to have him testify on, but if it's in his report,
It's in his, it broadly is in his report. I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes. Obviously, we're going to ask him, we've already asked him to review. He's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation followed standards and training, best case practices for an investigative
so I guess
technique.
that's my question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see?
This is wild to me. This is wild to me. You are a judge. You are a judge. Where are the standards and best practices for a police investigation? That's your question, ma'am? Really?
Codification of it, or is
So-
it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we would use to propound that Bowdoin defense.
Right.
Can you get me that report before you leave? Do you have it extra?
I think we probably have.
Of course, Ms. Little is nodding because Ms. Little is the keeper of everything this judge wants. And she's always prepared.
Mr.
And
Easter was
now,
a agent who did CAST, he did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowdoin. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police.
but if he
This is just Monday
reviewed,
morning quarterbacking, and it's an
oh
attempt to
my God.
bolster argument by counsel so that they can use some type of opinion to lean on when they're arguing to the jury they should have because of the police investigation. I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol,
if your police had done a better job, this wouldn't even be a thing. All right, I'm gonna skip ahead to we're gonna. He goes on to say, well, what if I bring in my, what if I bring in a Canton police officer to say this was the best investigation in the history of ever? And we will, I'm going to let Alan Jackson respond to that.
With Mr. Brennan, he indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were?
Yes.
There's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says,
You
well,
wouldn't
hang on.
be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Mr. Brennan said, what if I called in a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words. Do it.
Sir, you missed an opportunity. Yeah, bring it. Bring it, Brennan. Because here's the thing. I have learned from all of the attorneys on the interwebs that I watch that under normal circumstances, yes, he would object and should object for the appeals. I don't think they're gonna, because I think they're like, put my expert against anyone on Canton PD any day of the week. Let's do this. You mean you want me to cross-examine the guys who used a leaf blower to clear the snow? Yeah, bring it.
Do it. I'd love that. I'd love a shot at that.
So I said, let's take personal.
That's not an invective. That's not a personal shot at Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we're entitled to present a defense. And part of that defense, the Bowden defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation is not something within.
I don't know. So if you can give me a case site for that, all right, that expert testimony regarding a Bowden defense, I've never seen it. I've never seen it in research or anything. So
I've got
a
it.
Case site.
There are certainly cases outside the jurisdiction.
Yeah, Massachusetts case. If not,
that I hate. That I absolutely hate. No, it has to be a Massachusetts case. She's not going to give this to them. She's not going to let this expert come in, and it will cause issues with the jury. Maybe she'll surprise me. Sometimes she does. I'm going to let him finish, but the way she tends to signal her rulings, if they can't find a Massachusetts case, because who needs an expert to say how bad a police investigation is? Normally, you don't need that. So if we need that here, that's the problem, Judge. That in and of itself is a problem, in my opinion.
you can give me the outside cases, but I don't believe there's a Massachusetts case where this has been done.
We have searched and searched for a specific case in Massachusetts. There, to my finding, to our finding, there isn't one directly on point, but there are plenty. There is a myriad cases outside the jurisdiction where investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
Right.
That is an expert field, one that's utilized throughout the country all the time.
Some authority, and the more persuasive the authority, the better chance you have at this. Okay.
Sure.
All right. So I think that's it for the motions in limine. Did I miss anything?
And that was court for the day, and they scheduled, I'm going to embiggen myself. I'm going to make my note. That was court for the day. They are back in court this week. I'm still mad at that. The higher the authority, the more likely I am to grant your motion. The fact that it's even needed hurts my brain. But if you missed that first trial, the Canton PD, which should have been conflicted off the case from the get-go, didn't secure the crime scene for a significant amount of time. Nobody questioned anybody in the house in the moment. They kept letting witnesses all chat together. People weren't being separated out. And then on top of that, there seems to be no chain of custody. And yeah, they were collecting blood evidence in red Solo cups and then dropping it in a Stop and Shop bag and then leaving it in the Sally Port near the car for days on end, if I remember correctly. I mean, it was I still can't get past leaf blower and red Solo cups. And I'm not going to get past that. And Stop and Shop bag. It's just, that was the moment in trial 1 where the Commonwealth completely lost me. So these are the motions in limine. I tried to zoom. We managed to take a 5+ hour day in court and condense it down to almost 2 hours. I'm long-winded. I took a lot of soapboxes. I know. I hope that this, and then we will see what we're looking at as we go back into court this week. We are April 1st is right around the corner, and they are going to start working on impaneling a jury, even if they are not going to swear the jury until like April 25th. I could use everything being pushed out a little bit because I am going to need to take a little break from streams myself coming up. We will handle that in a week or so. Maybe next week we will check in on the state of the world as well for just a minute. I don't know. Anytime these attorneys end up in this court, things turn into an episode of Law and Order and have that level of drama. So I'm not counting on anything. New motions were filed today. I have not caught up on those yet. Hi, thank you for hanging with me this entire time. I appreciate it. If you like all of this, and if you're replay crew, I love the replay crew. Replay crew is great. I am mostly replay crew on a whole lot of my favorites as well. It means we can all watch on our schedule. Pardon me. Oh, pardon me. Okay. If you like everything, do all the things. Do the liking and the subscribing things. Welcome to everybody new. I try to keep things to an hour most of the time, but let's be real. I'm long-winded and these court days are long. So I do what I can, but I can't always succeed on that. Yep, do all the things. I thank you so much for hanging with me. We will be back next Sunday, although keep an eye on the socials there, because, well, brain buffering. Sorry. That's where I keep things most up to date, and that's where you will get the quickest notice if I am going live, because I don't know what's going to happen this week with court and work and things. So, deep breaths. Keep up the good fight. I am looking for something. We're here. Wow. Nope. That was a full, my brain, full squirrel. Full squirrel moment. My apologies, everybody. Okay. I am getting there. I'm going to see you next Sunday, if not before. Thank you for being here. Thanks for hanging with me. As I always say, be well, do good, and remember to bark a lot. And I will see you on the next one. Thanks for joining us for another episode of The Unfiltered Tea. Don't forget to hit that like button. If you have a story you want our unfiltered take on, go ahead and drop it in the comments, and we will see you next time.